Globally, as of 5:56 p.m. Central European Standard Time, June 28, 2023, there have been 767,518,723 confirmed cases of COVID-19, including 6,947,192 deaths reported to the WHO, more deaths than attributed to Adolf Hitler during the Holocaust, in half the time. And, as of June 20, 2023, a total of 13,461,344,203 vaccine doses have been administered. And yet, as noted by Jamie Metzl, a former WHO official and writer for the Wall Street Journal, more than 3 years after the start of the global pandemic, there has yet to be a comprehensive forensic investigation into its origins. According to former WHO official Jamie Metzl, there are two competing hypotheses. Some believe the novel coronavirus probably escaped from a laboratory in Wuhan. Others maintain the virus first jumped to people from caged animals at a Wuhan seafood market. And, it is the opinion of Mr. Metzl that testing either hypothesis would require access to Wuhan lab records, biological samples, and personnel, as well as frozen blood samples collected in 2019 by various Wuhan blood banks, but one retired strategic counterintelligence officer for the U.S. Army has persistently disagreed, and had filed with the White House, on March 23, 2021, a request for documents under the Freedom of Information Act, or FOIA, just less than 2 weeks after the anniversary of the pandemic declaration, when the American president, Joe Biden, had observed that the total deaths in America numbered 527,726, which he had described as more deaths than in World War I, World War II, the Vietnam War, and 9/11 combined. Today, that number is 1,132,872. Under the FOIA, any person making a request to any agency, including the White House, shall be deemed to have exhausted his administrative remedies with respect to such request if the agency fails to comply with the applicable time limit provisions, and, on complaint, the District Court of the United States in the district in which the complainant resides, or has his principal place of business, or in which the agency records are situated, or in the District of Columbia, has jurisdiction to enjoin the agency from withholding agency records and to order the production of any agency records improperly withheld from the complainant. Yet, while the FOIA request had been acknowledged as received by the White House on March 23, 2021, the White House, under a presumptive assertion of executive privilege, which is reserved for matters of national security, to be determined, upon challenge, by an in-camera, or in-courtroom, examination, the White House elected a dubious right to remain silent, refusing to issue any response at all to the request that had simply sought to determine whether certain standard epidemiological metrics, i.e., secondary attack rate and/or infectious dose for COVID-19, were classified information, because to that date and since these metrics have not only remained officially unknown by the CDC, but also the published assessments regarding these metrics appeared to defy the clinical capabilities that had been presented by this novel coronavirus of an etiology quite singular, performing in a manner that appeared almost alien in gain of function, and clearly in an aberration from nature, at least as known to science on Earth. For instance, after a review of 55,924 laboratory-confirmed cases that had been reported in China by February 20, 2020, by 1,800 teams of at least 5 epidemiologists, 19 times more cases than had yet been reported in the entire US by mid-March of 2020, investigators had found a secondary attack rate, or SAR, ranging between 0.9 and 4.8%, which is at least 12 times too low to validate the presence of a highly contagious disease that might be capable of setting off a superspreader event, and yet, even if these anomalies had been of alien origin, these officially unknown and yet standard epidemiological metrics could not be classified information, under Executive Order 12,958, could not be classified information, unless the U.S. government had owned and or controlled the causative biological agent for a disease that has been attributed to 6,189,621 hospitalizations in the U.S. alone, and 103,436,829 cases of infection, at least 12% of which have been reinfections with the virus. The White House has elected a right to remain silent in the press about their refusal to respond to the FOIA, and intriguingly, on May 26, 2021, just 2 months after acknowledging receipt of the FOIA request, the American president, Joe Biden, had asked the intelligence community to redouble their efforts to collect and analyze information that could bring us closer to a definitive conclusion, explaining at the time to the American people and the entire world that the U.S. intelligence community had coalesced around 2 likely scenarios, but had not reached a definitive conclusion on this question. According to President Biden, at that time, while 2 elements in the IC lean toward the former scenario and 1 leans more toward the latter, each with low or moderate confidence, the majority of elements do not believe there is sufficient information to assess one to be more likely than the other. However, given a secondary attack rate of less than 5%, like the chances of an applicant being accepted to the prestigious Harvard University, the novel coronavirus could not either escape from a laboratory or evolve from a zoonotic source so as to escalate into a pandemic, as it had, and, on July 7, 2021, Major Mike Webb began his first attempt in the courts to compel a response from the White House regarding whether standard epidemiological metrics for COVID-19 were, in fact, classified information. If these metrics were, in fact, classified information, not only would the government have to have owned and or controlled the virus for which many had been mandated to be administered the COVID-19 countermeasures products, as they had been described in the Emergency Use Authorization Declaration, published on March 27, 2020, the novel coronavirus could only have found its origins in a laboratory, a conclusion that Dr. Anthony Fauci, and many other notables in the medical and scientific community have consistently denied. However, on the same day that the final, unclassified report from the intelligence community was published, a federal district court in Richmond had dismissed the case against the White House for specious reasons, a dismissal that prompted 2 appeals that had been presented to the United States Supreme Court, distilling the official government position to a global statement on the origins of a novel coronavirus. The government could neither confirm nor deny that it owned the virus. On March 24 of this year, Major Mike Webb revived the action to compel a response from the White House in the Federal District Court in Washington, D.C., and, on June 21, 1 day after the primary elections for Arlington Democrats, the court had quashed an attempt to have the United States Marshal serve the complaint and summons on the White House to bring it under that court's jurisdiction, a matter from which it had remained a fugitive of justice since shortly after the first anniversary of the pandemic, and the court issued a minute order compelling Major Mike Webb, a candidate for the state legislature against the Virginia Democratic Caucus House Majority Whip, Alfonso Lopez, in Virginia's 3rd House District, to perfect service of process against the White House, without the assistance of the United States Marshal before July 21, or the case will again be dismissed. Should the White House finally capitulate to accept the complaint and jurisdiction of the federal court, it will have only 21 days to provide a responsive pleading that will hopefully present more details regarding why the American President Joe Biden has remained reticent to the American people and elusive from the courts. Under Terry v. Ohio, from which the Terry stop received its name, in determining whether the officer acted reasonably in such circumstances, due weight must be given not to his inchoate and unparticularized suspicion or hunch, but to the specific reasonable inferences which he is entitled to draw from the facts in light of his experience. And, after reviewing the conduct and statements of one notoriously accused minister of the Third Reich, Adolf Eichmann, that tribunal, sitting in judgment, had concluded that undoubtedly he knew the value of the tale about administration of tonics, to which he put his signature. That is the news for now in Arlington, and we shall keep you posted on this developing story.
This message was approved by Major Mike Webb. Honest.